Caveat emptor means buyer beware and is a legal doctrine that places the obligation on the buyer to perform due diligence before purchasing a property. The principle requires the buyer of real estate to accept the property as is, free of any warranty by the seller as to the quality or quantity of the land purchase, or as to its suitability for the purchaser's purpose. Essentially, the buyer must take responsibility for investigating the quality and condition of the property. Representations and warranties in the offer to purchase create exceptions to the caveat emptor rule. A common misconception in the real estate industry is that sellers are required to disclose every defect or deficiency in a property. While sellers are required to disclose material latent defects, meaning defects that are not readily observable and could render the property unfit or unsafe for use, this is a very high bar to meet. A seller is not obligated to advise of defects that are obvious or should be discovered by a reasonable inspection. For example, visible cracks in the wall or worn-out flooring are conditions that buyers should notice when they view the property, and the seller does not need to draw the buyer's attention to them. Emphasize the importance of due diligence to your buyer clients. While a property disclosure statement may be a helpful starting point when considering possible problems with a property, buyers should not depend on it as the definitive source of information. Advise your client to seek professional inspections or advice regarding any concerns they have or to help uncover issues that may not be immediately apparent to an untrained eye. Remind your client that an inspector can only inspect parts of the property that are accessible, and they will not open walls, pull up carpet, or do anything else that may damage the property, though some inspectors may use specialized equipment such as infrared cameras to check for heat loss or moisture, or drones to check the roof. Explain to your buyer clients that sellers do not need to disclose issues that are obvious, but they must be honest when making representations about the property. The buyer should carefully review any property disclosure statement or other representations, warranties, or information, such as the listing description provided by the seller, and ask additional questions about the property's condition if they have concerns. Remember, property disclosure statements are limited to the best of the seller's knowledge and belief. To further protect your buyer client, it is a good idea to include conditions in the offer to purchase related to satisfactory inspections or the buyer obtaining specific expert advice for areas of concern, such as electrical. Ensure that you include wording in the condition indicating that the seller will agree to make the property available for the inspections your client wants. Sometimes a buyer may want their offer to include certain warranties made by the seller, although it is ultimately up to the seller whether to accept such an offer. While buyers are responsible for ensuring they have properly investigated a property before purchasing it, there are circumstances where the buyer may have legal options for compensation if a problem is found after possession. For instance, the buyer may seek compensation or other remedies if the seller failed to disclose a material latent defect or was dishonest in their representations or warranties about the property. Sellers have also been found liable where the representations they provided contained silence or half-truths that led the buyer to believe further due diligence was not required. Note that if the salesperson representing the seller was aware of a material latent defect and did not disclose it, or that the information being provided to the buyer was untrue, they could also face liability. Additionally, if a buyer obtained title insurance as part of the transaction, they may have coverage for unknown title defects and claims that were not discovered until after the possession date. This may include issues related to zoning or bylaw compliance, builder's liens, or unpaid utility charges. However, remember that title insurance is not property insurance. It does not insure property defects such as electrical or foundation issues, water seepage, etc. For more information on title insurance, review the episode linked in the description. If your client has questions about their options for compensation after finding a problem with their property, advise them to speak to their lawyer.